Good morning to all. This is Dr. Pallavi Gupta. Today I will discuss medical negligence. Under the medical negligence, I will discuss the introduction, meaning of medical negligence, definition of medical negligence, forms of medical negligence under different laws, component or ingredient of medical negligence. Okay. Regarding the introduction, why doctor should fix for medical negligence when doctor considered as a god? Medical profession is one of the most reputed professions in the world. As we know that doctors are considered as God because they serve our lives from several diseases. So they are given much respect in our countries, in in our society, and moreover they do their work for human being and their safety. The main profession for them is to help people to come out of any disease. This is either this is their duty to focus on their research to help the mankind in future as well. But then a time comes when the savior does not remain the savior, but becomes devil himself. Here we are talking about the negligence in the medical profession. Doctor always need to be focused on their work, and they should be always exact in their work, because when they are advising someone on their health issues, then they cannot take a chance to give them wrong advice or do something wrong in surgery, because it can cost anybody's life. But it is an irony that we have several cases of the medical negligence around the globe. You can see the common errors that lead to negligence. We see this surgical errors, retain obstacles in the body, paralysis from the septics, wrong patient. See the number of the errors which lead to negligence in the medical profession. Regarding the meaning of medical negligence, whereas meaning have been attributed to negligence, one negligence negligence refers careless state of mind which may amount to recklessness of indifference. Negligence is a careless conduct without reference to any duty to take care. Negligence refers to a breach of duty to take care. Further, we can explain that negligence cannot careless state of mind which may amount to recklessness or indifference. In cases where physician prescribing drugs and dangerous side effects without informing the patient of risk of those side effects and without carrying out the recommendation test in order to discover whether such side effects are happening, in guilty of carelessness in exposing the patient to the risk of suffering from those side effect of the drug. This meaning of negligence is the basis of the criminal liability. Negligence is a careless conduct without reference to any duty to take care. The best illustration of such careless conduct is found in cases of contributory negligence. A patient undergoing medical treatment under the care of a cook exhibits such careless conduct. This meaning of negligence also found in performance of contractual duty. Negligence refers to a breach of duty to take care. Lord Wright points out negligence means more than heedless or careless conduct, whether in omission or commission. It properly cannot be complex concept of duty, breach and damage. Medical negligence means negligence resulting from the failure on the part of doctor to act in accordance with the medical standard in practice, which are being practiced by an ordinarily and reasonably competent man practicing the same profession. So this is all about meaning which are attributed differently by different person by different cases accordingly. Regarding the definition of medical negligence, definition given by Justice Alderson in the case of Smith versus Brington Waterworks Company, it says that medical negligence medical negligence is doing something a reasonable man would not do, and not doing something a reasonable man do. Therefore, medical negligence can be defined as doing something a reasonable doctor would not do and not doing something a reasonable doctor would do. This approach has been used in this for the next case, the Volam versus Friend Hospital Management Committee. Although in this case, Justice McNair defined medical negligence. Medical negligence in an act or omission by a healthcare provider which derives from accepted standard of practice in the medical community and which causes injury to the patient. Therefore, medical negligence is defined as the commission to do something which a reasonable man guided upon those considerations which ordinarily regulate the conduct of human affairs would do, or doing or not doing something which a prudent or reasonable man would to do. He is doing something and not to doing something. As a common definition, which comes through as a gist of the definition used by different judges in different cases, like medical negligence can be defined to an act which occurred with the lack of reasonable care or willful negligence by the doctor in respect to all aspects regarding patient, from showing the confidential report to the patient to some unknown person, to making diagnosis and examination without permission. Moreover, doctor's negligence can be proved when he had a duty of care towards his patient, but he breached his duty and the patient suffered injury due to that breach of duty to care. Now we will discuss the several forms of the medical negligence. Broadly, it is divided into three. First, we can say the negligence in which the consequences are foreseen and wrongly intended. Second, negligence in which they are not intended but are foreseen and should have been avoided. Negligence in which they are neither foreseen nor intended but ought to have foreseen and avoided. The first form of negligence is, of course, a crime, but a medical practitioner must always be careful enough to avoid the second form of negligence because defense available is not always sufficient. Regarding the third form of negligence, the law presumes that a doctor should be careful to avoid the unforeseen dangers because of his specialized training. Regarding the component or ingredient or essentials of medical negligence means what essentials are necessary to constitute medical negligence. Okay. As per the view of Charlesworth versus Percy, it says there are three components or essentials to constitute medical negligence in modern tort of law, that is existence of duty to take care, breach of such duty and damages. Uh, Charlesworth and Percy says that negligence is a tort which involved a person's breach of duty that is imposed upon him to take care, resulting in damage to complainant. According to them, there are three essentials of medical negligence in law of torts. So therefore, it is says that if the plaintiff proves that doctor was negligent, but fails to establish that any loss or injury was caused thereby, he will not be entitled to get any compensation. The general test for causation requires that the plaintiff to establish that the injury would not have occurred but for the negligence of the defendant. As per the View Black Law Dictionary, it says that negligence per se means conduct, whether of action or omission, which may be treated as negligence without any proof, either because it is a violation of a statute or valid municipal ordinance or common law, that it can be said without doubt that no careful person would have been guilty of it. Means the person who is careless will be guilty of the medical negligence. Therefore, to constitute medical negligence, whether there is a negligence in service by the doctor done by the doctor or not, there are certain ingredients to constitute medical negligence. Finally, doctor owes a legal duty of care towards the patient. Doctor has breached the duty of care. Patient has received physical and mental damage that is can be used as an injury. Patient has received injury or damage due to breach of the duty of care by the doctor. Duty. Okay. Regarding the first duty, doctors owes a legal duty of care towards the patient. Negligence per se, a carelessness, is not culpable or a ground of legal liability, except in those cases in which the law has imposed a duty of carefulness. Meaning thereby negligence per se as a conduct as a careless is not a ground for legal liability unless there is a duty imposed by law. The duty of care exists only when the doctor-patient relationship is established. The doctor-patient relationship automatically starts if a doctor approaches a patient with the intention of treating or healing. No bilateral agreement is required. When does the doctor-patient relationship end? It continues until the need for care is over or until an alternative arrangement has been made willfully. In the government sector, a doctor cannot end the institutional responsibility of doctor-patient relationship. There the patient does not select a doctor but goes to the institution, then a responsibility is originated between the institution and the patient as well. Therefore, doctor cannot end this doctor-patient relationship without patient's consent. Therefore, when doctor in a government sector go on transfer, the doctor-patient relationship automatically transfer to the doctor who takes care. Whereas in private sector, the doctor can end it by giving sufficient time and option to find another doctor because there is no institutional responsibility. However, in case of an admission to an emergency unit of a private sector, patient cannot select the doctor but the institution. And an institution responsibility of doctor-patient relationship is established, and the doctor in such service of private sector also cannot end this relationship without patient's consent. After establishing the doctor-patient relationship, the doctor must employ an accepted practice and reasonable skill and care appropriate to his knowledge, experience and position when exercising his duty of care. Such accepted and reasonable duties of care include a valid consent must be given by the patient, life of the patient must be respected, and attempt to save the life from the outset. They should treat patient without discrimination. Investigation or test should be performed adequately. Referral to other experts and the diagnosis of the condition should be done. The fee should be reasonable. Uphold the right of uphold the right of the patients or their relatives. Professional confidentiality should be maintained. Alcohol should not be taken while on duty. Therefore, a legal duty exists whenever a doctor or hospital or healthcare provider undertake, undertakes care or treatment of a patient. Duty of care include doing all the investigation, irrespective of their results, diagnosis the disease promptly and properly, treatment of the disease, and follow up the patient till he gets completely cured. Regarding the second ingredient of medical negligence, is doctor has breached the duty of care. Second essential to constitute medical negligence is that doctor must not only owe duty to take care to patient, but he must be in a breach of this duty to take care. A duty is breached when a doctor or hospital or healthcare provider fail to conform to the relevant standard of care. The standard of care is proved by has to be proved by expert testimony. There are three judicial approaches which are developed uh, along with the time. That is the accepted practices. Second, we can say the ordinary skill, and third is the reasonable patient. And this is developed in the different cases. Let us take the first approach, judicial approach, accepted practice. In 1995, in the case of Blith versus Brington Waterworks Company, this is the case of 1856. The patient of a doctor was considered the practice of a doctor was considered and assessed whether the doctor used and accepted practices. In 1955, in a case Hunter versus Handley case, the Scotland. This is the case of Scotland, where where the court introduced accepted medical practice approaches to consider whether there is a breach of duty or not. In this case, due to breaking of a hypodermic needle while receiving an injection, Hunter suffered injury. He sued the doctor and he had to prove that there was an accepted practice, and the doctor failed to follow that practice in giving injection. But doctors are not expected to use an accepted medical practice always, and are encouraged to find new practice in order to improve the medical science. Further, doctors are not always expected to follow the best practice. When assessing the accepted medical practice, the court evaluates whether a minimum acceptable standard of care was provided. Ultimately, it is up to the court to decide whether the medical care is reasonable or not. Meaning, thereby, the judicial approach was given in the Waterworks company case. That was the accepted practices, and in the case of Hunter case, it was later, it is not always necessary to follow by the doctor as a accepted practice, because there is a lot of advancement in the profession, and it is not also necessary to adopt best practices also. It depend upon the case to case and doctor to doctor. And the second case is related to ordinary skill. In 1957, in the case of Wollum, okay, this is known as a Wollum test also. Wollum versus Fran Hospital Management Committee. The skill of a doctor were considered and assessed whether an ordinary skill was used by doctor at the time of treatment of the patient. In this case, a doctor, a Fran Hospital permitted a doctor to administer ECT, electroconvulsive therapy, for volume desperation. Here the patient was patient of depression. So here the practice was the treatment was given by the doctor known as the ECT, electroconvulsive therapy. So ECT was administered without prior administration of a relaxant, without using manual restraint to control convulsive movement, and without warning him of the risk of convulsive movement of ECT. While taking the consent, means while taking the consent of the patient, the warning was not given. What shall be the risk by using this therapy? In the course of ECT, the pelvis was fractured on both sides. Therefore, Mr. Olam sued the Friend Hospital management for negligence. The approach of ordinary skill was introduced by the Justice McNair in this case. He stated that in case of an ordinary man, the conduct is judged by the conduct of an ordinary man in the street or a passenger in a omnibus. But in the case of a competent man, some skill, some special skill or the competency is involved, and the test of the man in the street or omnibus cannot be used here. It is sufficient if he exercise the ordinary skill of ordinary man when performing the particular art. Therefore, in case of a doctor, the court expects the standard of a ordinary, reasonable doctor at his or her level in the profession and does not expect the highest expert skill. Therefore, Justice McNair expressed that if a person acts in accordance with the practice accepted as proper by a responsible body of the medical man skilled in that particular art, he cannot be found to be negligent. Similarly, the specialists are judged by the standard of care expected from person in the same specialty. This is called as a Boland test. Means it will be just the practice adopted by one person and adopted by other person, and both are expert. And if it is the similar, the doctor will not be liable. Uh, yes, and further, the Boland test has been used to judge non-disclosure of risk when requesting consent from the patient, non-disclosure of the risk when requesting consent from the patient. In that cases also this volume test has been used, as in the case of Sidway versus Board of Governor of Wetham Royals Hospital. In this case, Miss Sidway underwent laminectomy of the fourth cervical vertebra. She is the patient of cervical disease. So that was resulting in the paraplegia due to the spinal cord injury in the in the Royal Hospital. Here, the Miss Sidway was the patient of cervical disease, and during that treatment in the hospital, Royal Hospital, her spinal cord got injury. Got injury. The hospital was sued by Miss Sidway for non-disclosure of the risk of the damage to the spinal cord. She said if she had been warned, she would not have consented for the surgery. The House of Lords rejected her claim, stating that the issue of non-disclosure constituting a breach in the duty of care has to be decided by the expert medical evidence according to Mullen test. Means that time there was not a practice to disclose the risk involved in a particular treatment. Third, judicial approach of reasonable patient, as in the case of Chester versus Ashfar. In 1997, in Voltio versus City and Heckler Health Authority, the UK court, this is the case of UK court. Expert medical evidence was sharply challenged in this court. UK court deviated from the volume test for the first time in this case, and the judge stated that the court must be satisfied that the body of opinion in questions rest on a logical basis. Then the patient-oriented approach was introduced for the case of non-disclosure of risk. In 2004, in the case of Chester versus Ashfar, court introduced reasonable patient approach for failure to disclose a risk of treatment. In 2015, further, in the case of Montgomery, court overruled the Bolam test and the patient-oriented approach in UK was confirmed. Meaning thereby this Bolam test was overruled in 2015 in the Montgomery case, and the approach of reasonable patient was adopted here in the case of non-disclosure of the risk. Therefore, a doctor must disclose the risk that would be considered material or significantly by a reasonable patient. It was decided that the reasonable patient test should be used to assess all forms of medical negligence. Therefore, now in deciding medical negligence, the court may not rely solely on evidence of medical profession like in the earlier era, but may listen to different expert views and apply its own principle of logical reasoning with judicial perspective. Now, the third ingredient to constitute medical negligence, the breach of duty was proximate cause of injury which was reasonably foreseeable. This is the third and most essential ingredient to establish medical negligence on the part of doctor, that the patient has suffered damage known as an injury, although the damage may be physical, mental, or financial. If there is no damage to patient, the patient cannot succeed in his action. The patient must establish that the damage sustained is the result of doctor's negligence by act of commission or omission causing a breach of duty owed to him. Meaning thereby, if law imposes a duty on the doctor to do something and if he fails to do, then it will be considered, and damage caused to the patient, then it will be says that patient has received the damage due to the breach of duty imposed on the doctor. If doctor is having a duty to do something and he fails to take care, and the patient get injury, then it will says the doctor that the damage occurred to patient is the result of breach of duty imposed on the doctor. Now the fourth essential or ingredient to constitute medical negligence. Without damage, there is no basis for a claim, regardless of whether the medical provider was negligent or not. Therefore, it is needed to establish the causation, means connection of the damage. This means the damage was caused by the breach of duty of care by the doctor. Means there is a need to establish a connection between the damage occurred to patient and it was a result due to the breach of the duty imposed on doctor. It can be further illustrated in the case of K versus Ayrshire Health Board, Scotland. In this case, a 2-year-old boy who was seriously ill with meningitis is it is a kind of fever caused by penicillin. In this case, a 2-year-old boy was seriously ill with meningitis caused by uh, Streptococcus pneumonitis. Was given a huge, means a huge dose was given of a medicine. It was toxic medicine, and it was overdose, and the overdose of that medicine was given to him. Doctor realized his mistake immediately and gave intensive care. Patient recovered from both meningitis and penicillin overdose because of intensive care, but the child was found to be deaf afterward. His parents sued the health board. Two explanations for deafness was identified: meningitis and overdose of penicillin. The doctor admitted breach of his duty of care, but denied that Key's deafness was the result of that. Trial court favored, given the decision in favor of the patient, but appeal court favored the defendant doctor. The House of Lords reconfirmed the appeal court judgment because deafness was a well recognized complication of properly treated meningitis, but little or no evidence that large dose of penicillin caused deafness, and it is not a foreseeable cause. Therefore, to establish medical negligence, a plaintiff, that is a patient, must establish all four of the following elements, ingredient or component for a successful medical negligence claim. These are the protections, although these are the protection barriers in favor of patient that helps them to be safe from such doctors. Moreover, these barriers stop doctors from doing wrong things. Therefore, finally, to establish medical negligence, plaintiff, or we can say the plaintiff, must establish all four of the following elements for a successful medical claim. Next lecture will be depend on the jurisprudence of medical negligence, meaning I will discuss some case laws where the judiciary laid down the meaning of medical negligence in under different laws in different way. Thank you for listening me.